Have a quorum. We have a hard stop at 3, and so we are going to get through this agenda if we can. If not, then the bills we don't get to will be on tomorrow's calendar. As always, if you want to be heard on a bill, please come sign up at the sign-up sheets up here. I'm going to ask Senator Hatchett to open us up in a word of prayer.
Thank you, Mr. Chairman. Heavenly Father, thank you for bringing us here today. Please continue to speak to us and help us to do your will for the people of the state of Georgia. In Jesus' name I pray. Amen.
Thank you for that. Representative Corbett, are you speaking on House Bill 1528? Okay. I'll tell you what, come on, you're the only one I see, unless I'm missing somebody else as a House member here. Come on up and get us started. We'll look at the second to last on your agenda, House Bill 1528. It's the committee substitute, LC 393437S. This is a different bill than originally came from the House. Representative Corbett will explain it, but it's an issue he worked on the House side that is now House Bill 1528. And the floor is yours. Let me turn you, there you go. Now you're live.
There you go. Well, thank you, Mr. Chairman, members of the committee, and it is an honor to be here today. Let me just a little background how we got to this point. I chaired Motor Vehicles Committee in the House, and last year it brought us, all these motor vehicle crimes that we're having, not just in Atlanta, it's happening all over the whole state. I mean, from break-ins, smash and grab, to auto thefts, fraud with steal a car and register in somebody else's name, and catalytic converter theft is rampant. We had one just 2 weeks ago. Had a House member had his stole off his Toyota Tundra, and $4,400 to get that replaced. But I mean, it's rampant. So we had a hearing in the off session last summer, and took testimony from a lot of different entities, from recyclers to GBI, local law enforcement, rental car insurance companies. And anyway, it's just a huge problem, and that brings us to here. And this one of the recommendations was to form an advisory council or board to be able to receive grants, to be able to then appropriate those or grant grants to local law enforcement to help them fight these motor vehicle related crimes. So that's how we got here. Now I'll start with my other comments. Local law enforcement agencies across the state are grappling with motor vehicle crimes. Crimes range from auto theft, parts theft. There's especially been a spike in catalytic converter theft, insurance fraud. The common handicap that all agencies is limited bandwidth to attack the problem. Limited personnel, equipment, technology, access to data, boundary jurisdictional restrictions. The purpose of this board is to tackle this bandwidth handicap by establishing and operating a statewide program whose mission is to provide funds and capabilities to local law enforcement throughout the state dedicated to reducing motor vehicle crimes. The board is modeled after auto prevention authority programs that have been established in numerous states and have proven results at reducing auto theft crimes. Maryland, Virginia, Colorado, Texas are just a few that have successful initiatives. We pull these authorities, the components that have proven to be effective to fight against motor vehicle crimes. In Colorado in 2020, 84% of all reported stolen vehicles were recovered, is well above the national average of 56%. Between the years 84 and 94, vehicle theft in Maryland increased by 143%. After 94, they created a commission and reduced that by over 53% for estimated savings over $123 million, and that was in Maryland. Funds will be used to provide financial support to state or local law enforcement agencies for motor vehicle crimes investigation, and can include vehicle theft, parts theft, fraud related to motor vehicle insurance, auto dealer, auto rental purchases, and other forms of financial fraud. Providing financial support to local prosecutors dedicated to the prosecution of motor vehicle related crimes. Providing funds to local law enforcement agencies for training purposes, providing funds to local law enforcement for equipment and technology to help aid in the investigation and prevention of motor vehicle crimes, potential funding for multi-jurisdictional task force to improve law enforcement bandwidth, information, and resources, The board will be established with members made up of local law enforcement, industry stakeholders to execute the commission's mission. So that's how we got here, and we'll speak to the bill now, if you would, Mr. Chairman. We're looking at HB 1528, LC 393437S. And I go through it fairly quick. Lines 14 through 40 basically establishes the grant program and uses of the grant. 41 through 62 deals with the type of programs that will be implemented by each grant application and provides examples of those programs. 63 through 65 provides, to the extent possible, grants, what the grants will be awarded in a variety of geographical areas across the state, trying to, instead of concentrating just in Atlanta, to be awarded all over the whole state when possible. 65 through 67 provides that additional monies or matching funds is not required as a condition of receipt of a grant. 68 through 72 provides that the council may accept and use federal funds as well as gifts and donations from individuals, and that the acceptance of these funds does not place an obligation on the General Assembly to appropriate funds in the future. 77 through 97, line 77 through 97 provides for the makeup of the board, who will be appointed by the governor. Lines 100 through 117 provides for terms, compensation, and replacement of members of the board. And then the very last part, lines 120 through 2 through 144, basically this is cleanup language, because this is going to be housed at the in the Criminal Justice Coordinating Council. And there's other boards in that council. So the last part of the bill, like I said, lines 122 through line 42, just clears up the different boards and then what council means, and then the Juvenile Justice Advisory Board, and then the Criminal Case Data Exchange Board. Just clean up language in there to make sure that we keep the boards separate.
All right.
Is what we're doing there. That's what the bill does. Like I say, it's been very successful in other states when they've done this. So I stand for any questions this time.
All right. Any questions for Chairman Corbett? We have one person signed up to speak. Derek Corbett. Bring your family to help you.
Well,
Come bring him on. Don't explain it. Come on up.
I wish. I think he has money.
Pull apart. You want to come up and
I would claim him. I think
sit tight with your cousin. Come here. If you come up and Mr. Corbett. Good afternoon.
Good afternoon. Thank you for having me. And I'll be brief because Chairman Corbett did a great job explaining the bill. I work for Pull Apart. We are one of the country's largest auto recyclers. So auto theft and auto crimes hit us square in the back pocket, either stealing off of vehicles before those commodities make it to our yards, or breaking into our yards and stealing from our yards. We know how robust auto crime is. Part of my role with Pull Apart is to work with our auto theft investigators around the country. We have facilities between here and Arizona, and so I work with all of the local auto theft investigators, including the International Auto Theft Investigators, also known as IATI. And what we hear, as Chairman Corbett pointed out, is that bandwidth is the number one challenge that they face. Bandwidth in personnel, bandwidth in data, bandwidth in access to data, bandwidth in technology, bandwidth challenges when it comes to your prosecutors, who have a difficult time investigating what really is a very white-collar-esque crime in auto crimes. So I believe that this legislation really hits a vast majority of the needs that our local law enforcement agencies in Georgia have said that they need. So we are supportive. Not only are we supportive, we're excited at the effort and would love to see it be successful. Thank you.
All right, any questions for the other Mr. Corbett? All right, thank you.
Thank you.
All right, no one else is signed up to speak on the bill. What's the pleasure of the committee?
Mr. Chairman.
We have a motion to pass by Senator Hatchett by committee substitute. Is there a second?
Second.
Second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously. Who's going to carry the bill in the Senate? Senator Hatchett? Okay,
Senator Hatchett.
Senator Hatchett. All right, thank you.
Leader Hatchett.
Appreciate it, Mr. Chairman.
Thank you.
All right, back to the top of the agenda, House Bill 961. Chairman Abstration, working off LC 441842.
Thank you, Mr. Chairman. I have some handouts of the committee aid. We'll be willing to hand those out. That'd be terrific. Two different ones. Thank you, Chairman Strickland, members of the committee. This is House Bill 961, as passed in the State House of Representatives in August of 2021. The Georgia Supreme Court issued an opinion in Alston and Bird versus Hatcher Management Company. The the opinion interpreted existing law to have the ultimate effect of if a party is if there's only one defendant on a case, but say responsibility is apportioned percentage-wise in a less amount than 100%. Because only one defendant was named in the suit, that one defendant must bear 100% of the costs. So the example that I give is if I am, say, the victim of a crime on Senator Hatchett's property, and a jury were to determine that the person that robbed me is 95% responsible, but he's 5% responsible for a failure to have lighting, security gate, things like that. If I only sue him, he's got to pay 100% of my damages. And this would just restore the law to how it worked prior to August of 2021, and would allow a defendant in that circumstance to only pay the amount consistent with their responsibility in the case. Very appropriate questions been raised as to constitutional questions around the effective date of the bill. So this would be effective upon signature by the governor for all lawsuits filed after that date. And we have letters that were just handed out, one from Legislative Counsel, Mr. Higbee, stating that in his view an equal protection challenge would not be successful. It's constitutional under equal protection question. And additionally, that former Georgia Supreme Court Justice Keith Blackwell also issued an opinion. He's now in practice, and he issued an opinion that he believes House Bill 961 is constitutional as well. Would ask for your favorable consideration. Pass the House unanimously, I believe. Would appreciate y'all's support.
All right, thank you, Mr. Chairman. Any questions from the committee? All right, there's no one else signed up to speak on. Oh, you have a question, Senator Hatchett.
Yeah, thank you, Mr. Chairman. Chairman, I appreciate you. That was one of the questions I had, and I do appreciate this. These handouts that you gave. I feel a lot better about the constitutionality of where we are with this, and want to thank you for bringing this piece of legislation.
Thank you, Senator.
All right. Nobody else has any questions. What's the pleasure of the committee? Everybody, let's see. Motion to pass by Senator Kirkpatrick and a second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is also unanimous. And who's going to carry this in the Senate?
Senator Kennedy.
Senator Kennedy. Okay.
Thank you very
Mr.
much,
Chairman. We'll see you soon.
Thank you. Yeah, see you soon.
All right. Next bill on the agenda is House Bill 1377. The other chairman, Chairman Burchett. Welcome back.
Thank you, Mr. Chairman.
We're working off of LC 442015S. Did you bring me any gifts this time?
No, I didn't.
Okay.
Holding on to that gavel, but may deliver it soon.
Okay.
If you need it.
I may.
Okay.
Yep.
Mr. Chairman and committee members, I have before you House Bill 1377, and this provides for a right of action or cause of action for any person when a company is misclassifying their employees. The issue that we're trying to rectify is where a company is not classifying their workers as employees and they're 1099 in those people instead of taking out the labor burden taxes and unemployment insurance. That's what the bill does. It only provides for injunctive relief, so no damages here. So in other words, the judge says stop, don't do this anymore, do what you're supposed to be doing. There's a bond requirement if you're going to take the extraordinary effort to require a temporary restraining order, then you must put in place a bond that will cover the cost of any damages to whomever you're bringing the suit against. Also, we put in a provision so that this is not abused, that if you lose, the loser pays here. And that's the gist of the bill. I'll stand for questions.
All right. Any questions from the committee? Do you have a question from Senator Kennedy?
Yes, sir. Thank you, Mr. Chairman. Thank you, Representative, for bringing this. I think I understand the purpose behind it and the policy objectives. I just want to make sure I understand the extent of the remedy that you have fashioned. So looking on line 14, it says any person can bring the cause of action. So it doesn't have to be anyone injured, doesn't have to be the government, it doesn't have to be anyone even with a nexus to the employer or the employee.
That's correct.
Okay. Are there other examples of where you found where there's a similar type statutory scheme where there's no connectivity, if you will, between the plaintiff or a putative plaintiff and someone that's bringing a cause of action like is being proposed here?
Well, the closest thing that I can say that is like this piece of or cause of action would be like a key tam. So if you're familiar with a key tam practice where an individual is suing to enforce the laws of the federal laws, that's similar to this, but that's the only thing that I can say that is closely related that I know of, Mr. Kennedy.
Okay. And if you would look on lines 15 and 16, the other language that I was drawn to, it says to provide to seek relief to require such employer to comply with all applicable provisions of this title. What all, and I'm not looking for a quote, but generally what all is included in this title that you're really gearing toward with this is injunctive relief?
So this title has to do with how a employer is to tax their employees or withhold the taxes for their employees. So the only thing we're after is a scenario, and I'll give you the exact instance that was brought to me. I've got a business owner that is in a competitive environment and competing against another business. Now, this business owner is paying the labor burden. He's paying his withholding his taxes. He's withholding the unemployment insurance, but he's competing against a guy that is just 1099ing his employees. Well, there's two benefits to that. There's no administrative oversight for 1099. You just write a 1099 at the end of the year. This is how much I paid in the wages. And then secondly, with the pandemic, we've got now employees for the business that is correctly withholding taxes coming to them and saying, if you do not 1099 me, if you don't pay me $150 a day or $200 a day, then I'm going to go work for company B, who is just 1099ing. This is a problem that has been brought up to the Labor Department, and the response that the Labor Department gave me and the company in question was that these folks are not in the system. We can't do anything about the folks that are not performing under the law. So we're after the bad actors. This does say any person, though, so it could be broadly interpreted. But the provisions that we put in here so that it was not abused was loser pays and the requirement for a bond, because that is a certainly a substantive concern.
Okay. One more, Mr. Chairman. And then, and by the way, I like the approach to go after this because there is an unfair playing field out there for people that abuse the system and mischaracterize employees as something else. On line 16, it says, provided that no showing of special or irreparable damage to the person shall have to be made. Is the person referenced in that provision the plaintiff that's suing, or the object of all of this, and that is the employee or someone that should be classified as an employee?
I mean, Senator, I read that as the plaintiff, but
okay.
And that's the intent, certainly. In other words, it's overcoming a standing provision and saying that you don't have to have damage or harm to bring this cause of action.
Okay. Tying back into anybody can bring it.
That's right,
okay.
Yes, sir.
I think if that's who that person is, I think it's appropriate. I think if it was you were intending the employee, then I think we had some other problems, but I think otherwise. Okay. Thank you, Representative Burchett. Thank you, Mr. Chairman.
And when I first read your bill, my first thought was, why would you let anybody have standing? But I think what got me was the example you gave. There may be a difficulty in showing special damages if you want to try to sue to enforce. And showing as a competing business owner what your damages are could be difficult to articulate too. Or do other states have similar laws like this?
I don't know of any other state that has a law like this. Essentially, we're trying to allow our citizens to enforce the laws of the state of Georgia. It's already unlawful to misclassify your employees, but the enforcement arm is unable to reach some of these, most of these issues. I don't have to, and I don't know what the number is, but there's a significant number in the case where we're not withholding our taxes of revenue that's not being sent to the state. The number is has been quoted to me, and I can't back it up, so I don't want to give you a number, but it's substantial.
And who's the current enforcement arm?
Well, you could say the Department of Labor or the Department of Revenue.
Okay. Chairman Tillery?
I don't have any questions.
All right, before we do that, any other questions from the committee? We have one person signed to speak on the bill, Mr. Brett Hume with the Southeastern Carpenters Regional Council. Come on up. You can sit there, Mr. Chairman.
Thank you, Mr. Chairman, committee members. Brett Hume, Southeastern Carpenters Regional Council. Just a couple of comments in support of the chairman's bill here. We have found this to be factual. For some cases, the bad actors use this as a business model. The Georgia Department of Labor audits 2016 to 19 show an estimated 276,000 Georgia workers are misclassified annually. So this is a huge problem, and unfortunately, if you're going to modify bad behavior, it seems financially is the way to correct that behavior. So the carpenters stand in support, Mr. Chairman.
All right. You do have a question, Senator Hatchett.
Thank you, Mr. Chairman. I understand the intent of the bill and, trying to prevent an employer from gaining an advantage in the workplace, paying employees, obviously improperly. But I'm just concerned, and maybe you can address this, the way the bill's written, it just says an employer that fails to properly deduct and withhold. My question is, if I'm an accountant or an office manager for a company, and let's say I withhold too much, and technically that's improper, or I'm taking too much out of their paycheck, and they'll get a bigger, tax refund at the end of the year. Would that be a violation of this code section, the way it's written?
Is that question to me or the chairman?
Well, either one.
I think that you could perceivably say that could be a violation, but who is going to bring the action? I mean, what would be the initiative to bring the action? Because what we have in here, Senator Hatchett, is a requirement. If you bring the action and then you lose, you have to pay attorney's fees.
Mm-hmm.
So that was I think that's a good, valid concern, but I think that I don't know who would bring the action in that case.
Okay. Thank you.
On that point, because you have to, it says as required by code section 48-7-101, I guess you would get to a point does that code section require you to have the exact amount properly withheld, or is there something else written in that code section as to the obligation of an employer? And maybe something to explore on that. One thing brought up from Legislative Council is we have, I'm just going to turn, Mr. Walker, do you want to just reference it directly versus you trying to read it?
Thank you, Mr. Chairman. Just the question earlier regarding the reference to this title in line 16. The title would therefore be Title 48, which would be the entire revenue code. So if the focus of the bill was on withholdings or income tax provisions, it may be that referring to the chapter that this is in is Chapter 7 of Title 48. and that deals with income taxes rather than the entire revenue code.
You have any
So,
comments on that?
You know, if that's the case, if that's the way if it's the broader portion of the entire title, then we need to narrow it just to the withholdings portion.
If that were the case, I would recommend then just replacing title with chapter in line 16.
Thank you.
All right. Any other questions from the committee? All right, no one else signed to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Tillery. Is there a second? Second by Senator Kennedy. Chairman Tillery, do you want to offer the amendment?
Line 15, that,
Line 16.
is it 16? I'm reading, I'm sorry, I'm on the wrong version of that one. I'm now on the committee substitute, sorry. That the word, Michael, I defer to you, but I think you strike the word title and you would enter instead any provision of, or strike the word this title, of Chapter 7 of Title 16?
Would be appropriate just to replace the word title with chapter, therefore it would refer
Chapter.
to this chapter.
Okay. Strike the word title and insert the word chapter.
All right. Is everybody clear on the amendment? Is there a second?
48.
Second by Senator Kirkpatrick. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It's also unanimous. All right, back to the underlying motion to pass as amended. All those in favor, please raise your hand. It's unanimous. And who's going to carry the bill in the Senate? This is your way of asking me?
I was
Make
asking
it hard
if
to
you
say
would-
no?
Yes, or anybody you would recommend.
Okay, we'll figure it out. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Thank you, committee members. I appreciate that. Thank you.
All right, House Bill 274, we're going to hold on till tomorrow at the request of the author. And so we are going to move down to House Bill 1068. It's a committee substitute. Representative Leverett, LC 510198S. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, and thank you for agreeing to hear the bill. Greetings to the members of the committee. It seems like old times, I suppose. Senator Kennedy might think this sort of reflects a familial obsession with service of process on my part to bring another service of process bill, but this is actually originated, as all good ideas do, with a constituent. I have a constituent who's an attorney who occasionally brings claims against the state under the State Tort Claims Act. There is a specific statute that deals with service under that act. It's 50-21-35, and this bill proposes to make some changes to address a problem that has arisen. Under that statute, service is required upon two different people. The chief executive of the agency involved and the director of risk management services at the Department of Administrative Services. Of course, those people tend to be very busy. They don't sit around their office all week. So what they have done in practice is we'll appoint a designee to receive service for them to stay in the office. The problem is there's absolutely no statutory basis for doing so. Secondly, they sometimes cannot be found there even with the designee. So what we propose to do in the House Bill 1068 is just simply to give some statutory foundation to the process of appointing a designee, and also to require that that information be posted on the agency's website, and that the designee be present 3 days of the week so that they can be found for service. The substitute you have reflects a few changes from the original bill, or from the substitute that was approved in the House. And basically, it was based upon some input that I received from the governor's office this morning. They had suggested that we make it designee or designees so that more than one person can be designated to receive service, which makes sense. That way you don't have one person tied to his desk for a certain period of time. And so what we did, just to point out the changes from the sub that came across, is in lines 10 and 11, we added or designees after the word designee and made the same change in 13 and 14. And then there was a slight change on line 21 of which is on the second page, where it now reads, a designee for service of process shall be present at the published office address rather than his or her. And the hope there is to make it clear that only one of the designees at any time has to be present. The one or more designees can split the 3-day time amongst themselves however they want to. You don't have to have one person in the office 3 days out of the week. So this is just a sort of a rather simple, practical solution to what is a practical problem that people have been encountering when serving under that statute.
All right. Any questions, Representative Leverett? All right. There's no one else who signed up to speak on the bill. Chairman Tiller, do you have something? Okay. We have a. What's the pleasure of the committee? Chairman Tillery says motion do pass by committee substitute. Second. Is there a second? Second by Senator Parent. Any discussion? We have discussion.
And I'll go ahead and say I thank you for working on it, because I know this was an issue with some of the folks down in my area, and thank you for hearing them and not wanting to tie one of their designees to a desk for 3 days. So thank you for your help.
Thank you, Mr. Chairman. I appreciate that.
All right. Any further discussion? We have a motion do pass by committee substitute. All those in favor, please raise your hand. We're still all together. It passed unanimously. I know. We'll see if he continues for the last bill. Who's going to carry this one?
Well, I was hoping Senator Cowser might finally find one of my bills that finds favor with him, but he's not here to ask.
We'll sign him up. Senator Cowser it is. All right. Thank you.
I do not know at this point, but we're working.
Senator Cowser will carry it. All right. Thank you.
He loves service of process.
He does. So he gets to not being here. All right. Last bill on the agenda. You're always last. I don't know why. Come on up. Representative Gaines, House Bill 689. We're working off a committee substitute, LC 442097S. Full disclosure, a whole different issue on this bill than we had previously as passed the House. So talk to us about the new House Bill 689.
Well, I will first mention the original language that we passed in the House is on Senator Tanya Anderson's bill that is now in the House, Senate Bill 257, which is a great measure and very supportive of, and we fully intend to get that out of the House. So had an opportunity to try to help a colleague of mine, Representative Beth Moore. She had a piece of legislation to help our four-legged friends, our dogs, and that would allow dogs to be able to join us. They currently can sit at the patio of a restaurant, but the restaurant cannot serve any food to dogs. What this would allow is for human-grade food. So, for example, have a menu. This is in some other states. There's a company, I believe they're here, called Lazy Dog, that offers it. Their pup menu includes a bowl of water, plain brown rice, grilled hamburger patty, brown rice and veggies, and grilled chicken breast, brown rice and veggies. So it does have to be human food, but would allow for these restaurants, if they so choose, to offer that for our four-legged friends. Yeah, this is in the restaurant group would estimate that by not allowing this, it costs these restaurants up to $250,000 in revenue by having this prohibition. So I think it's a good bill that cuts red tape, and some other states do allow it. I believe there's 7 other states, and they're working to expand. But the Lazy Dog folks, I believe, are here, can talk about their experience in other states. NFIB is supportive of this measure. I believe they may be here as well. But happy to answer questions, and frankly, some of the other speakers may be more experts than myself on this.
Well, we always talk about the slippery slopes. Let me go there. So we have dogs now. What if it includes pigs down the road? And I'm thinking about the awkward situation where somebody's in a barbecue restaurant. You see where I'm going? How do we get ahead of that?
I'm not going to answer that one.
Okay. Well, you do have a question. It may not be any better from Senator Kirkpatrick.
No, I'm not going to try to be funny. I have a serious question about They have to have a separate dishwasher, or how does that work?
So DPH DPH would be authorized to write the rules and regulations on all that, which I suspect that would. And DPH is here; they could talk a little bit more to that. But we left most of the particulars of how this would be operated, utensils and those sort of things would be totally. DPH would write the rules and regulations for that.
Follow up, please.
And DPH, I believe, is here.
Right, but if they're operating in 6 other states, it's being dealt with in other
Right, and they
states.
could
So
take-
how are they handling it?
I would defer to Lazy, the folks. They're here as well. Lazy Dog is here. Maybe could answer that.
Yeah, so we did not sign up, but we do have Mike from Lazy Dog here if he wants to talk about
Yeah,
his
maybe.
processes.
Is it okay if he comes?
Let me ask a few more questions in the committee. I'll call you back up, okay? The questions just went away. Okay. Do you want to come up then and answer her question? That must have not been serious questions.
Based on Chairman Tillery's face, I
Yeah,
suspect
he
that to
pulled
be
back.
true.
He read the room.
Thank you for having me.
Hey.
Protection.
Just to briefly address the question about the utensils, we would always defer to the Department of Public Health and any preference that they had. Currently, it's all disposable, and in most other circumstances, whether it's state or county led, if a dog does eat off of a human plate, let's say that you handed your plate down to a dog, we would actually dispose of that plate. So we wouldn't rewash it. We would actually get rid of that plate so that we'd never have cross-contamination. But at the moment, currently, it's disposable. It would be something biodegradable that we could use just for the dogs, and then we get rid of that product.
All right. You might introduce yourself for the record.
Sorry, my name is Michael Ogilvie. I'm the regional director out here in Georgia and the southeast of the country for Lazy Dog Restaurant and Bar.
All right. You do have some questions now.
Yeah.
Senator Watson? Which mic are you, 13?
Yes,
Okay,
the
there you
lucky number 13. Are you, what states are doing this now?
Currently, we have Nevada, Colorado, Florida, Chicago, Virginia, California. I believe that's it, but I might be missing one. Hoping to add Georgia as well.
Chicago wasn't a state list.
Or Illinois, I apologize. I don't do this often, sorry, I'm working through it.
So it is done statewide, it's not done anywhere by cities or?
To be honest, most places it's county driven. And that's, I think, a little bit of the roadblock in Georgia is we have to try to move the ball this way. A lot of places it is county driven. In Georgia, we did have to move it a little bit at the state level. When we have had any roadblocks in the past, and again, this is for all restaurants, not just for us. When we have had any roadblocks in the past, we would go to the county and handle it at that level, usually with a partnership with the Department of Health. But that wasn't the case here, so we're just trying to do everything the right way and make sure that we're abiding by all state laws and regulations.
Are we going to have DPH testify or? Okay, great, thank you.
All right, any other questions from the committee at this time? All right, I'm going to call the other speakers up. Ms. Megan Andrews with DPH. If you want to step aside for a second.
So does this preempt the local?
Hi, Chairman, members of the committee. I'm Megan Andrews. I'm the Assistant Commissioner for Policy at the Georgia Department of Public Health. I wanted to come up today to provide you all some background on the history of this business, this variance that they had applied for, as well as share some public health concerns so y'all are fully educated in your decision-making process today. So the public expects a certain level of protection to their health and safety when visiting a facility that's inspected and regulated by a government agency. The Georgia Department of Public Health is responsible for protecting individuals who visit establishments like restaurants, which are regulated by DPH. Under our current regulations, pet dogs are permitted on restaurant patios. However, employees and consumers are prohibited from providing food to these pet dogs while on the patio. This business sought a variance to our regulations in 2018 for the feeding of dogs on patios. This variance was denied for 2 reasons. First, the department has concerns about the risk of animal bites occurring on restaurant patios by food-aggressive dogs. The ASPCA has said that guarding possessions from humans or other animals is normal behavior for dogs, and the level of response by dog is going to vary from growling to biting or chasing off the person or animal. They further state that children are more likely to get bitten because they are less able to recognize a dog's warning signals and are more likely to behave recklessly around the dog. Having a 3-year-old, I can agree with that. DPH is also responsible for responding and investigating any animal bites that occur in the state and institute rabies mitigation measures as appropriate. The second reason for the variance denial is that the risk for a dog defecating or vomiting increases immediately after eating. So though this business does have a policy for cleaning up dog accidents, which we fully appreciate, feeding dogs on patios may increase the amount of these occurrences and thus increase the risk of disease transmission at the food service establishment. I am here for any questions if y'all have any, but that is some of the historical background as well as the two concerns from DPH on this.
Senator Kirkpatrick.
I'm sorry, Mr. Chairman. My question, I guess, for you, Ms. Andrews, is doesn't the Department of Agriculture have some role to play in food safety also?
Yes, so this came up in House Committee. There were questions as to whether Department of Ag's feed regulations would come into play. So they regulate food that's given to animals. So I believe, and I haven't seen the substitute, but I believe the language that passed the House had something in there that said DPH is the sole regulator of this, and that was an attempt to carve out and make sure that they weren't being duly regulated by Ag as well.
And the sub does still say that they have to comply with the rules and regs established by such department, your department.
Yes.
We're getting you a copy of the sub so you see it.
Thank you. I appreciate that.
We have more questions. Senator Jones? Or is it? So, sorry, Senator Parent.
Thank you. Thank you so much. So one of the things I'm curious about is whether, I guess the setup that we have in Georgia does not allow locals to say, we want to run this type of establishment where we could have the dogs.
So we have our food service rules and regulations are adopted statewide. So every county that you go to in Georgia has the same set of food service rules and regs. So, if you own several McDonald's franchises, it's going to be the same rules no matter what county you go to. And that's to ensure consistency. A lot of other states, they do county by county. They may have strange carve-outs for a specific business in their county that wouldn't apply to every other county in the state. So, like Florida is an example of that.
Thank you.
Senator Rhett.
Thank you, Mr. Chairman. I just kind of came in. I'm trying to catch up here. The type of dogs we're talking about, are we referring to if somebody needs a CNI dog, or are we talking about just any dog?
Yeah, the intention here is any dog. So it could be a service dog or it could be a pet dog.
Mm-hmm. Thank you.
All right. Senator Hatchett.
Thank you, Mr. Chairman. Right now, does the department allow pet dogs inside restaurants to eat?
No, just service dogs.
Okay. So no establishment in Georgia is allowed to, or can have dogs inside?
They can, no, just on the patio.
And this wouldn't change that.
Right. And
Okay.
they have to have a separate entrance so they don't go through the interior of the restaurant to get to the patio.
What about if it's not, I guess, a food service establishment? Does that include bars or breweries?
Yes.
Oh, introduce yourself too. I'm sorry.
I'm sorry. My name is Galen Baxter. I'm currently the Environmental Health Director for Fulton County, but I used to be the Food Service Director for the state of Georgia under DPH. But so the Department of Agriculture will regulate some breweries, but if there's food service or if the beer does not get distributed off-site, then it would fall back to the Department of Public Health for regulation.
Okay. Yeah, I guess the reason I ask is I think in the past I've been to breweries and if dogs are inside. So would this would not apply to those?
Those facilities would be I think they're under the Department of Agriculture. So any establishment that's regulated by DPH currently, no dogs are allowed inside.
Okay.
Only on the patio.
Thank you.
Do you have another question, Senator Rhett?
Yes, sir. Thank you, Mr. Chairman. If we pass this legislation, will restaurants be legally compelled to comply, or will it be on a volunteer basis?
Yeah, so if this passes, DPH would have to adopt rules and regulations governing how this will look in Georgia, how it's going to be set up. Restaurants, it's up to them. If they, right now even, restaurants don't have to allow dogs on patios. If they don't want to, they can, as a personal property owner, they can say no dogs on my patio. Same thing with this. If they don't want to have a dog menu, they're not forced to have a dog menu. It just requires us to adopt new regulations to allow it.
How do you interpret the language of the bill? Doesn't say when you have to adopt that, it just says you shall. How does the department interpret that? When would you actually adopt rules and regulations if the bill passes?
So this would go into effect July 1. So we would probably begin working on rules and regulations immediately after session to prepare for the July 1 start date.
All right. Other question from Senator Parent?
Mr. Chairman, it just occurred to me, I have been to a ice cream establishment where they sell little cups for the dogs. Are they in contravention of existing law?
So there is actually a avenue right now for restaurants can have a dog menu. What is not allowed is for dogs to consume the food on the patio while there's other people dining. So the ice cream example, they sell like a pup cup or something like that.
Right.
The owner of the dog can take that, go to their car in the parking lot and feed the dog there. What's not allowed is the area that we regulate, so the restaurant itself and its patio, they're not allowed to be feeding animals right now under our regulations.
Thank you.
Yes.
Are any other questions from the committee for Ms. Andrews? All right, thank you.
Yes.
There's one other person signed up to speak, Mr. Nathan Humphrey, NFIB. Good afternoon.
Good afternoon, Mr. Chairman. I think this is the first bill I've ever testified on dealing with animals, but I'm proud to be here. My name's Nathan Humphrey. I'm with NFIB, represent small businesses here in Georgia. One of the things, I love this bill for many reasons. One, particularly as we've watched businesses fight just for survival during the pandemic, we've noticed a lot of creativity and innovation in how to adapt their business model to be successful and survive. And the business climate and environment that they work in is constantly changing, and they're having to adapt and find new ways to do business. And when a business finds a way to do that, I think we should do everything we can to be supportive of that. One thing I'd like to point out, Senator Hatchett, you asked about food and breweries currently. I actually went to 2 breweries and 1 restaurant this weekend. I've got 2 kids, and there were a lot of birthday parties, I guess, on patios and breweries. Now that's a new fad. And there were dogs at both breweries and the restaurant. And right now at breweries, they don't sell food, but you can bring your own food in. And there were a lot of dogs eating food at those breweries on the patio, inside and outside. And what we have here is a business that is wanting to play by the rules. They're wanting to follow the law. They're a good actor. And they've just come to us looking for help to follow the law. And I think we should do everything we can to help businesses that are doing that. I'm not throwing the ones that are not following the law under the bus. I don't think they even know that it's against the law. And this would not mandate anything on a business. It just gives them the option and flexibility that if they do want to do something on this, there is a path forward to do it.
All right. Any questions on the committee for Mr. Humphrey? Thank you.
Thank you.
Representative Moore, you want to close this out? And this was your bill, I think, originally.
Well, good afternoon, Senators. I did want to just add some additional context for the bill as it went through the House, just to let you know where it stood, before it just didn't get through rules. But I presented this bill twice to Ag, twice because the first time we just ran out of time and had to come back. But this bill has, even to my shock and surprise, broad bipartisan support in the House chamber. In fact, I've been told that this is in fact a Republican bill because it cuts regulatory red tape and is a free market bill. Of course, these are things that Democrats strive for as well. And so, you know, my number 2 co-sponsor of this bill is Sharon Cooper, the chairwoman of the House Health and Human Services Committee. Casey Carpenter is my 3rd co-signer. He is the only restaurateur in my chamber. He supports it. Bonnie Rich, the House chairman, and Joseph Gullett, who's my seatmate, and he and I have worked on a lot of animal safety bills before. So, you know, Chuck Martin, if you guys know him, he's a big supporter of this bill as well because hungry.
Don't hurt the bill now.
Yeah, I know.
I got to appear in front of him in like 5 minutes. Hope nobody told me that joke.
Well, because Lazy Dog is planning to open up a franchise in his district.
Yeah.
In fact, you know, we can ask Mike to confirm, but they currently have plans for 4 locations in Georgia, and if things go well, maybe more. So this is in fact what I would call a regulatory red tape cutting bill. You know, the Department of Public Health's job is to promulgate the rules or the laws that we promulgate. Right, to make sure that they are that these laws are safely administered, and that's exactly what they will do. You can see Part A says that if a restaurant wants to serve a dog menu on an outdoor patio, that they can, so long as they follow the rules and regs of the Department of Public Health. Section B says the Department of Public Health will be in charge of what those rules and regs are, and Section C eliminates the question that Senator Kirkpatrick had, I believe, about what role does the Department of Ag have. We just made it clear that this is strictly under the Department of Public Health, so there is no dual regulation. And in the House Ag Committee, there was almost unanimous bipartisan support. There was 1 no vote, but I've spoken to that member, and we'll see where he stands when it comes over to the House. But otherwise, if the Senate chooses to pass this bill, you will be the hero of dog lovers everywhere. So.
All right, we have a couple questions real quick. Senator Kirkpatrick.
Yeah, I should have asked this to our public health folks, but I know that in Georgia we have cat cafes, and I wanted to see if they are being handled the same way.
Yeah, that's definitely a question for them. This bill is only about dogs, and it is not about pigs.
We're not getting into the pigs or whatever you said. Senator Watson, did you have a question, or Senator Hatchett, or who is Senator Calzert? Can't tell
Just curious, can humans order off this dog menu as well? Is that
You know, if the human
said it was human food. I mean,
if the human customer would like unseasoned hamburger meat for lunch, then I don't see any reason why not.
Yeah.
So like a new version of the kitty menu.
Senator Watson, Dr. Watson.
So, just FYI, it has to be prepared there. I mean, our dog doesn't eat human food, eats only dog food. What are we supposed to do with that situation?
Leave your dog at home.
Oh man, I'm a dog lover. We don't want to. What? You
just
gonna
the
make me
answer.
leave my dog home? I'm against this bill.
All right, we're running out of time. We do have one question Senator Kirkpatrick wanted the answer to. If you want to step back up, Ms. Andrews.
Thank you.
Thank you.
Yes, so we do have cat cafes in Georgia. How they are able to operate right now, I know. Who knew I'd be talking to Judy about this? How they are regulated right now is you go to one side of the establishment. That's where you can order your food and drink. They are all on disposable. It's essentially like a takeout order. Then you go to a separate room that is not connected to the restaurant area where food is prepared at all. If you choose to take your food over there and consume it with the cats, that is your choice. So that is how we regulate cat cafes.
All right, no further questions from the committee. We have, what's the pleasure of the committee? Motion do pass by committee substitute Senator Parent. We have a second by Senator Watson. No discussion, no amendments. All those in favor of the motion, please raise your hand. It is unanimous, and Senator Calzert's carrying this. That's right. No, not one bit. All right. With that, we are adjourned. Thank you.